This is your jury charge dictation for Performance Challenge week number 11. Ladies and gentlemen, at the close of arguments of counsel, it is the duty of the judge to instruct you upon the principles of the law that should govern you in your consideration of the evidence and in reaching your verdict, period. You will now be given these instructions, period, paragraph. It is your duty as members of the jury to take the law as it is given in the judge's instructions and to apply that law to the facts in the case which are properly proven by the evidence, and therefore arrive at your verdict, period, paragraph. It is your duty to exclude from consideration everything except the evidence received on this trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach a verdict, period, paragraph. If during the trial of this case I have given, or in the course of giving these instructions I may give, to any member of the jury an impression of my opinion concerning the guilt or innocence of the defendant, I charge you to disregard such impression entirely and to decide the issue of fact in this case solely as you view the evidence, period, paragraph. You, the jury, are the sole judges of the facts, and the court is the judge of the law only, period, paragraph. The district attorney has filed 2 informations, period. The information in the first case contains 9 counts, the information in the second case contains 6 counts, period, paragraph. An information is nothing more than a formal written accusation against a defendant, charging him or her with the commission of one or more criminal acts, period. You are not to consider it as evidence against the defendant in any way, period. It does not raise any inference of guilt, period, paragraph. In determining the guilt or innocence of the defendant, you should look at the evidence with the utmost care and caution, period. You should act with all the judgment, reason, prudence, and discrimination you possess, period. If, after this review of all the evidence, you have a reasonable doubt of the defendant's guilt, you must find him not guilty, period, paragraph. The law presumes every person charged with the commission of an offense to be innocent, period. This presumption attends the defendant throughout the trial and prevails at its close unless overcome by evidence which satisfies the jury of his or her guilt beyond a reasonable doubt, period. The defendant is not required to prove his innocence, period, paragraph. The burden of proving the defendant guilty of every element of the crime charged is upon the state, period. Before you can return a verdict of guilty, comma, the state must prove to your satisfaction beyond a reasonable doubt that the defendant is guilty, period, paragraph. If you can reconcile the evidence upon any reasonable thought consistent with the defendant's innocence, comma, you should do so and find him not guilty, period, paragraph. The term reasonable doubt means a doubt based on reason and common sense, period. It is a doubt for which a reason can be given, comma, arising from a fair and rational consideration of the evidence or want of evidence, period. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life, period, paragraph. A reasonable doubt is not a doubt that is merely fanciful or speculative, comma, such as a skeptical mind might suggest, period. A doubt that ignores a reasonable interpretation of evidence, comma, or one that arises merely from sympathy or from fear to return a verdict of guilt, comma, is not a reasonable doubt, period. A reasonable doubt is not merely a doubt such as may be conjured up in the mind of one desiring to escape the responsibility of a decision, period, paragraph. While it is your duty to give the defendant the benefit of every reasonable doubt, comma, you are not to search for doubt, period. You are to search for the truth, comma, and you are to give the defendant the benefit of a reasonable doubt if it arises in your minds after you have carefully considered all the evidence in the case, period, paragraph. You are to disregard entirely any question to which an objection was sustained by the court, period. You are not to speculate regarding what the witness's answer to such a question might have been, period. If such a question implied that certain facts were true, comma, you must disregard any such implication, comma, and you are not to draw any inference therefrom, period. Paragraph. During the trial, comma, the court has ordered certain testimony to be stricken, period. You are to disregard all such stricken testimony, period, paragraph. You are not to consider as evidence any exhibit that was marked for identification but was not received into evidence. Period. Paragraph. You are not to consider as evidence any statement or remark of counsel made during the course of the trial, comma, except stipulations or agreements of counsel, comma, if any, period. If such remarks implied the existence of certain facts not in evidence, comma, you are to disregard any such implication, comma, and you are not to draw any inference therefrom, period. Paragraph. Attorneys for each side have the right to object to what they feel are improper questions asked of witnesses and to the admission of other evidence that they believe is not properly admissible, period. No adverse inference is to be drawn from any such objection, period. Paragraph. By allowing testimony or other evidence to be received over the objection of counsel, comma, the court does not mean to indicate any opinion as to the weight of such evidence, period. You, jurors, are the sole judges of the credibility of the several witnesses and the weight of the evidence, period. Paragraph. You should consider carefully the closing arguments of counsel insofar as such arguments will assist you in arriving at a just verdict, period. But the closing arguments of counsel and their conclusions and opinions are not to be considered by you as evidence in this case, period. It is your duty to draw your own conclusions and your own inferences from the evidence, comma, and to decide upon your verdict according to the evidence and under the instructions given to you by the court, period. You may now begin your deliberations, period.